I'm Jim Astrachan.
And I'm Donna Thomas.
And we're from Astrachan, Gunst, and Thomas in Baltimore, Maryland. You can find our website at agtlawyers.com. So Donna, we're here today to discuss trademarks. Why don't we start by talking about the federal registration process? But before we do that, why don't you define what a trademark is?
Okay, a trademark is any word, name, symbol, or device. It could be a logo, it could be a slogan, could be sound, scent, could be trade dress, which is the total overall appearance and look of something. So just about anything you can think of that can serve as an identifying symbol can serve as a trademark.
Probably not taste. That's too subjective,
Probably
right?
not taste.
All right, and so we see these marks that you just described. And they have an R in a circle, or they say TM after them, or SM after them. Do those designations have any significance?
They do. So the R in the circle means it's a federally registered mark. So it's a mark that's been cleared and registered by the United States Patent and Trademark Office in the United States. When you see TM and SM, it's a designation of a claim of common law trademark rights. So they're not registered rights, but it's somebody is holding out a mark as belonging to them, as being used in association with some product or service, and it designates common law rights, which the scope of which differs from registration rights, federal registration rights.
So that requires a little bit of an explanation, and I guess the way to approach that is to ask you, what are the benefits, if there are any benefits, to federal registration of a trademark versus trying to protect your mark under the common law? Can you describe any of those benefits and what common law protection entails?
Sure. So probably easiest to start off with the common law.
And you notice I'm getting you to do all the work.
Okay, that's easy. I'm happy to. So common law rights, which are unregistered rights, arise out of usage of a mark in commerce. So trademark rights don't arise out of creation of a mark, they arise out of use of a mark. So when you use a mark to designate a particular service or a particular product, whether you're branding it or you're using it in advertising for a service, you establish what are called common law trademark rights. And the scope of those rights extends to the territory where you're actively advertising and selling products and services under the mark.
So let me stop you. I think what you just said is that you can rely on common law protection of your trademark, but it doesn't extend beyond the market in which you are in and your market of logical expansion in a reasonable period of time. So that if somebody was adopting a similar mark outside of your marketplace, you would not be able to stop that person because they would have common law rights, perhaps.
That's correct.
Okay.
So it's a market penetration test. So I have a lot of clients that call and say, well, I'm on the internet. So they assume they're everywhere, but that's not the case. It's really where you're actively marketing and selling your product and can establish market penetration through things like where your customers are, how much advertising dollars you spent in certain markets, how much sales you have in certain markets.
These are the same tests that you would apply to determine whether there's secondary meaning for a descriptive mark.
Similar, yes.
Similar tests.
Right.
Let's talk about the registration. Are there benefits to a federal registration?
Yeah, there's absolutely big benefits to a federal registration.
Big benefits.
So the biggest benefit of all for federal registration is that the scope of your rights extends to exclusively to the entire United States, even in territories where you are not, and they're exclusive as to the products and services for which you have registration. Now, they don't trump a prior common law user's rights. So if you happen to have somebody who has established themselves and is using your mark out in California at the time you secure federal registration rights, and you don't, as a federal registrant predate their rights, they still have their territorial rights. You can't take those away. But
and generally, you wouldn't be surprised to find out that there was somebody in California who had prior trademark rights because you would engage in a trademark search that should disclose that person, although it's possible it might not.
True. You would want to have a search beforehand, so you make an informed business decision when you adopt a mark about what the potential risks are, because the federal registration, which is nationwide in scope, allows you to expand, right? So even though you may not be out on the West Coast, if you have an intention of growing and expanding your business, the federal registration is going to preserve those rights vis-a-vis anybody who's going to adopt their mark after you file and secure your rights.
And you would want to know whether somebody had prior rights, because it might really put a crimp on your advertising. So, for example, you couldn't advertise in a national magazine. You might not be able to advertise on the internet in those markets. You might not be able to buy broadcast or cable in those markets, because that person might have prior rights. Is that correct?
That's right.
So let's talk about the process of getting a federal registration in brief terms, and how much it costs, and maybe how long. Well, let's not talk about how much it costs, because that can vary. But let's talk about how long it might take.
Okay. Registration process generally takes 9 to 18 months. It's kind of a long window because it really depends on the nature of any office actions you get. So when you file, it generally takes a few months to get assigned to an examining attorney who prosecutes the application, and the examiner identifies any issues that arise in connection with your filing. The most common of which is you need to clarify your identification of products and services, because they're very particular and they like to narrowly tailor the description, whereas the applicant wants as broad of a description as possible. You may get an objection that the mark's descriptive, or that the mark is likely to confuse with a pre-existing application or registered mark, which could result in a refusal. So there's a give and take with the examiner. There's an intent to use process as well as a use-based process. So when you go into the application, if you're using the mark, you would file a use-based application. If you are not, but you have a bona fide intention of using the mark, then you would file an intent to use application, which has an additional step of demonstrating use.
So let me back up and talk about the intent to use, or the ITU process. Do you find that most of the marks that you file these days, and you have in the last 10 or 15 years, are registrations based on a future intent to use the mark in commerce, as opposed to I've already used the mark in commerce and I want a registration?
I would say they're probably 50-50.
Okay, and the ITU is a very important process not to be ignored, because it's a reservation system. So it enables you to apply for a trademark registration before you use the mark. If you use the mark, you would so notify the trademark office, and if all things are lined up, your registration would be retroactive to the date of your application. That's
right.
it.
Your priority use date basically is your application filing date.
And that's a tremendous benefit, isn't it?
It is. And there are a number of times where people file an intent to use, and they may be using the mark when they file, but there may be some aspects of the goods and services for which they're not using the mark at the time they file.
So let's break that down for a second, because you mentioned a minute ago that the registration only pertains to the goods and services set forth on the registration.
Mm-hmm.
So I might be using it for 5 categories of goods, but there are 5 categories, additional categories, that I intend to use it for. And so while I'm using it for 5, I might also file an intent to use at the same time for the additional 5 categories.
That's right.
So are you saying that you pretty much have to know what you're doing when it comes to this stuff?
Well, you do, because there's a lot of, it's not highly complicated, but there are a lot of nuances to it, and there are particular rules that the trademark office has issued. So you really need to follow the rules and know what you're doing, because if you screw something up in the filing, it may be something that you can't repair, and that you have to refile and kind of start the priority clock all over again.
And so you've been doing this over 27 years or so, is that right?
Mm-hmm. Probably 23, 24.
And it's taken you a long time to learn all this stuff. Well, I'm Jim Astrachan.
I'm Donna Thomas.
And we're from Astrachan, Gunst, and Thomas in Baltimore. Our website is agtlawyers.com.